What can we do now to protect assets in case my parents ever need to go into a nursing home? I meet with families every week who ask me this question. It used to be that the majority of families who came to see me were already in what I call crisis mode, meaning they had an immediate care need and it was already costing them tens of thousands of dollars a month. More and more though, clients are coming to see me who may not have an active care need and are wanting to know what they can do to plan ahead. In this video, I'm going to talk about one of the most common planning techniques that we use to protect assets for Medicaid ahead of time, and why it's also so much better to do this than to just give money away to your kids. But before we get into that, let me talk a little bit about who we're planning for. Let's first take a look at an example of a very typical client of mine, Flo and Joe. This being Delaware and living near the beach, Joe and Flo have a beach house that they like to visit on the weekends and spend time in the summertime. Joe and Flo are retired. They live in Newark, and their primary residence is worth about $600,000 with no mortgage on it. They are able to live off of their Social Security and pension payments without having to dip into their savings on a monthly basis. They are both 80 years old and in decent health, and they also have some money in IRAs. They own this beach house in Fenwick Island, Delaware, that's been in their family for a few generations, and right now it's worth approximately $1.5 million. Joe and Flo's goal is to protect the beach house for their 3 kids and grandkids. They don't want to ever have to sell it if they need long-term care. So what would we advise Joe and Flo in this situation? We would advise Joe and Flo to create an irrevocable trust. We put Joe and Flo's beach house into the trust. After 5 years, if either of them needed to apply for Medicaid, their beach house would not be a countable asset for Medicaid eligibility purposes. I've also included an illustrated version of how this trust works. Joe and Flo create this trust. They are what we call the grantors. They will name trustees of the trust. We generally do not recommend that they be the trustees of their own trust. The trustee's job is to manage any of the assets that we put into the trust and to follow the terms of the trust. Clients will typically name a child or a trusted person to be the trustee of the trust. Joe and Flo cannot be the beneficiaries of the trust, and the trust must state that it is irrevocable, which means you can't change it. Even though they can't receive principal from the trust, they can, in some circumstances, receive income from the trust, but this is generally not recommended. Even though Joe and Flo cannot be the beneficiaries of the trust, they can name other people who have access to the trust money under certain circumstances. These are called lifetime beneficiaries. These are the individuals who can receive money from the trust while Flo and Joe are still alive. After both Joe and Flo pass away, the trust will also say where the money goes. So who is this kind of trust for? This kind of trust is typically for clients who are in decent health. It is typically for people in their 70s or 80s who have savings or assets that they don't need to dip into on a regular basis to cover their living expenses. It can also be for clients who may not be in good health, but who have enough money to pay out of pocket for their care for 5 years. It can also be a good fit for clients who applied for long-term care insurance and were not able to get it, or for clients who are not able to afford or don't want to pay the premiums for long-term care insurance. So I've given you a really good example, a typical example of the kind of client that this trust is for, or who would be a good candidate for this kind of trust. But let's also talk about who this kind of trust is not for. Here's another example of a family who might come and see me, and they might want to protect assets but they are not a good candidate for this kind of trust. So let's meet Fred and Hazel. Fred and Hazel are both 88 and they are starting to slow down. Fred is getting a little forgetful and Hazel is unsteady on her feet and is now walking with a cane. They own a home worth about $350,000 and they took a reverse mortgage out on their house to help them cover their living expenses. They also have small monthly Social Security payments and small IRAs that they draw on each month to also cover living expenses. They have about $15,000 in total savings between a checking and a savings account. I would not recommend this kind of trust for Fred and Hazel. Fred and Hazel don't really have any assets to put into this kind of trust, and their health is such that they might very shortly need to use some of their money to pay for long-term care. If we moved their house into a Medicaid trust right now, and either one of them needed long-term care in the next 5 years, there would be an issue because they wouldn't have enough other money to cover their care costs. There's also a reverse mortgage on their home. Many lenders will not allow people to put their house in this kind of trust if they have a mortgage on it. So now we've talked about this trust and how we use it. But a lot of clients still ask me, why can't I just give my money away to my kids? Or why can't I just add my kid's name to the deed to the house? Or they may also say, I heard that you can give $15,000 a year away to anyone you want with no penalty. Why can't I just do that? So let's talk about that, because there are so many reasons why you wouldn't want to just give your money away to your kids. First of all, the rule about giving $15,000 away is actually an IRS federal and gift tax rule. And in the year 2025, that amount is actually $19,000. However, Medicaid does not care about IRS rules. If you give away $19,000 and then you need to apply for Medicaid within 5 years of making that gift, it will result in an approximately 2-month penalty for Medicaid eligibility. Instead of giving your money away to your kids, this kind of trust can protect your assets from your kids' creditors, bankruptcy, and divorce. If you gift the money directly to them, your money becomes fair game for those things. This kind of trust controls how the money can and cannot be spent. If you give the money directly to your kids, you have no control over that. This kind of trust also directs where the money goes when you die, and it avoids probate. You can also name a trust protector, typically a neutral third party in this type of trust, who can make changes to this trust if there are law changes or ambiguities. So even though this is an irrevocable trust, we do have some ability to make changes to it. In this type of trust, you can even retain what is called a limited testamentary power of appointment. This essentially allows you to change where the money would go when you die, even though the trust is irrevocable. So we've talked a lot about the advantages of using this kind of trust instead of just giving your money away to your kids in order to protect it. But what if Flo and Joe still didn't take our advice and instead they just transferred the title to their beach house to their 3 children? This will create a major income tax issue. After Flo and Joe pass away, even though they swore they never would, the kids need money, so they decide to sell the beach house after all. The beach house was only worth $50,000 when Flo inherited it from her mother, and the kids end up selling it for $1.5 million. By transferring the title to the beach house to the kids, instead of putting it into an irrevocable trust, the kids have now created a tax bill for themselves of over $200,000. Let me show you why. If you sell property that has increased in value, you have to pay income taxes on the gain in value. In this case, the gain was $1.45 million. Capital gains which is what this is taxed at either a 15% or a 20% tax rate. So that equates to over $200,000 and potentially close to $300,000 that the kids will have to pay in taxes when they sell the beach house. This huge tax bill would have been avoided if Flo and Joe had taken my advice and instead transferred their beach house into a Medicaid irrevocable trust. Yet another advantage of this type of trust is favorable income tax treatment in some cases, depending on how the trust is drafted. This is where you want to make sure you are working with an experienced elder law attorney. We can create this trust in a way so that even though the assets in it are not counted and are protected from Medicaid, they are still considered to be part of your estate for IRS purposes, which actually lets us take advantage of a major income tax idea called step up in basis. In plain English, this means that if you inherit something from someone, instead of having to pay taxes on the difference between what you or someone who gave it to you paid for it and what you sell it for, so in this case, the $1.45 million, you only have to pay taxes on the difference between the value of the property when you inherited it and what you sell it for. So in this case, if the beach house was worth $1.5 million when Joe and Flo's kids inherited it and they sold it for the same amount, they have to pay no income tax on the gain. So this is another reason why you don't want to just give your assets away to your kids while you're still alive. It usually ends up being a big tax advantage for them to inherit assets from you instead of getting them from you while you're still alive. There are also some other income tax benefits to this type of trust. It can be created so that any income that the trust generates is still reported on Joe and Flo's personal income tax return. In other words, there is no extra tax return for the trust, and Joe and Flo's kids don't have to worry about any tax issues on their end. The trust can also be drafted in a way that if the grantors put their primary residence into the trust and the trust sells the house while the grantor is still alive, they can also use their $250,000 primary residence capital gain exclusion. So to recap, if you're thinking about what your family can do to plan ahead to protect assets, creating an irrevocable trust to protect assets from Medicaid accountability is a very powerful tool. It may not be for everyone, but it makes sense in a lot of cases, and it's usually much better than just giving money away to your kids to protect it. As always, I have oversimplified these examples and explanations for ease of understanding. If you would like my free guide to protecting assets from Medicaid with irrevocable trusts, type trust in the comments and I will send it. The written guide has some additional in-depth examples and explanations. This is intended to be general advice. This is not legal advice. If you need advice about your specific situation, then you should contact an experienced elder law attorney in your state. Thanks so much for watching. See you next time.